and the UPDF for 80% of this bill, especially where it concerns the welfare of members of the Uganda People's Defense Forces. I don't think we could have, or we should have, any contradiction, because all policymakers are very interested in having members of the UPDF catered for their welfare, including those that have become casualties. They are injured. How does the public look after them? And I think the bill goes a long way to address some of those. And I've got to congratulate you, Honourable Minister. However, there is only one aspect, listening to my colleague and also following the public conversation. Only one. And we are shifting the attention of a very good bill to one issue: trial of civilians by the army courts. That is all. That's where this contradiction is coming from. Nothing else. We should be speaking the same language. So what is the issue exactly? Mr. Chairman, I would like to speak with my head, but also with my heart. In conversations like this, sometimes we use our hearts, become emotional, and we forget the common sense. Or sometimes we are too brilliant and we don't think correctly. I want to talk directly to the court-martial officers who are here. All this problem has been caused by you. All this conversation has been caused by you. Why am I saying it? You failed to do what you are supposed to do in the law and veered into other things. And where you would have a legitimate case, like I'm going to support you on some aspects, here, you've spoiled your case. So as we give you a law, don't cause us more contradictions and problems. Let me give you an example. If there is this civilian Abdul Katuntu found with grenades, artillery pieces, why would, even if I'm a civilian, why would anybody have objections in me being tried by the court-martial? Because that is the purpose of the court-martial. These are weapons which ordinarily should be a monopoly of the UPDF. These are just war materials. A civilian who is having this sort of weapons, caliber of weapons, really, we would not be so much having a wider conversation. But if you start to pick a helmet and that become, what do you call them, these people? Is it called beret? Whatever they are. And that becomes an issue. You are vulgarizing the issue. That's what the problem is. In law, and the learned Attorney General knows this, we all agree, if you aid and abet a crime, you are as culpable as the principal offender. That's the law. And we will not be having this problem if you people were restricting yourself to real service offenses and civilians aiding and abetting crime. We will not be having this conversation. Please listen to us. But once you veer into other issues because of other reasons, then you miss out on legitimate support. I hope you've listened to me. But I've looked at you, especially the gentlemen who are lawyers the other side. Please listen to what Ugandans are telling you. Just restrict yourself to the law and the purpose of the law. Let us go to the law now. Mr. Chairman, court judges came to the same conclusion. All of them had different reasons. So, you see, somebody will pick one reason from one judgment, then he thinks that is the Supreme Court decision. And thus, maybe at some point, we need now to sit ourselves and reconcile or harmonize the reasonings given by different judges. Because there is no single judgment which gives the same reasons. All judges came to the conclusion that it was unconstitutional, but giving different reasons. So can we go and address the reasons within the different judgment, such that we talk from the same length? Colleagues, you need to read those judgments. They are quite a number. And there is no lead judgment, except that the other one was the senior judge. Because if there was a lead judgment where all judges agree with the lead judgment, that would have been even easy. But the problem is every judge wrote his own judgment, but they concluded the same way. Now, to go back to say this is what court said, that's where I think we are having a problem. And we need to sit. I hope we get time as lawyers, read as lawyers, including the Attorney General's chambers, and we can harmonize. I hope we get some experts to give us some idea. You've invited them. And we can harmonize on that one, because it's quite easy to do that. Second, is it third? Any number. Mr. Chairman, let us look at clause 7. C. Clause 7C. Honorable Minister, why do we have this clause anymore in our laws? 7C. Members of the High Command as of 26 January 1986, whose names are set out in Schedule 3 to the Act. You know, I don't think it's very good drafting and legislating. To legislate for individuals. It is E. Yeah, it is actually E. This is not good legislation. That we are legislating that Abdul Katuntu is a member of the High Command until he dies. Really? I think we need to, first of all, the NRA has since then metamorphosized into the UPDF. It has moved on. Medals have been given. People have retired. I think the army should move on. For example, in this particular clause, Honorable Minister, assuming one is likely to survive up to 100 years, just imagine that you are having a 100-year-old officer to be a member by law of the High Command. It doesn't make legal sense, really, even common sense. So I think at some point, maybe this I should be talking to the UPDF, not to the minister. At some point, you need to revisit this principle. The officers have served, we've recognized them, they have retired, let them live their own lives. They don't have to be members of the army organ, top army organ by law. No. No, I think we need to revisit this. And I hope at some point you concede and we move on. Honourable Minister, look at page 15, U like Uganda. The commanders and experts as may be co-opted by the President to advise the High Command. You see, if you are advising the High Command, then you can't be a member. I think the High Command can co-opt people to advise them, not necessarily as members, but to bring their expertise. For example, we have seen members of cabinet, but there are people who sit in cabinet and advise cabinet, not necessarily them being members of cabinet. You would find, for example, National Planning Authority boss or Secretary General of the ruling party. I don't know whether it's possible. Those who come around, they listen into cabinet and they can be advised, but not necessarily that they become now members of the High Command. You need to look at this critically, because you need the services of advice, of experts. But you can't have an expert and then you are saying he's now a member. He's coming in as an advisor. And that's the power we need to give to the President to seek advice. Mr. Chairman, there is a good innovation by the bill of cross appeal, where you can appeal to the High Court. I think it's close. Clause 57?
Court of Appeal. This is a high court. They have created a high court.
You see, I still have a problem. When you look at 2, Clause 2, 225, Clause 2. I don't know, Attorney General, whether you're there? Subsection 1 shall not affect the operations of any sentence imposed by a court-martial other than a sentence of death imposed by the general court-martial. You see, it means that you can only appeal about death and whether the trial was proper, but doesn't affect the sentence. Why should you have such a clause? That if somebody has been sentenced to life imprisonment, for example, and then the Court of Appeal has found that it was an illegal trial, the sentence is not affected. That was my interpretation. I could be wrong, because it said subsection 1 shall not affect the operation of any sentence imposed by a court-martial other than a sentence of death imposed by the general court-martial. So if you had other reasons, you could explain to see whether this particular clause is not going to be misread or misconstrued to mean that you can actually find impropriety in the sentencing, impropriety in the legality and of the trial, severity, and or even lenience of the sentence, and yet it is not affected by the decision of the Court of Appeal. And why appeal to the Court of Appeal? I thought this is a subordinate court under 129. And subordinate to what? To the course of record. Meaning, if it is subordinate, it should be able to appeal to the High Court because it's subordinate to the High Court. Why are we jumping to the Court of Appeal? Yet this is a subordinate court. The chairman, there are two things I want us to address about parallel or competing jurisdictions. Already there is a penal code provision which provides for some of these offenses unlawful possession of firearms, for example. And now all the firearms you brought them here. What happens to the provisions of the penal code? Or we are repealing the penal code by necessary implication. Are we doing that? Because those provisions are there. And why are they there? It's because there are other weapons. For those of you who are used to weapons, I just see them. There are other weapons which are like for personal safety. For example, the small one, they call it a pistol. Yeah? It is now also listed, that one. But I see so many people carrying them. In any case, since when did a pistol become a monopoly of the UPDF? The word used in the bill is monopoly. But I see so many people carrying them. I see even the police has weapons, doesn't it? The prisons has weapons, doesn't it? The Wildlife Authority has weapons, doesn't it?
Private security.
These private security people have weapons, don't they? Are those weapons which the police has a monopoly of the UPDF? Does the police need permission from the UPDF to hold those weapons? Does prisons need permission from the UPDF to hold those weapons? Because there are two categories of weapons, in my view. I'm sorry, I'm not an expert, but in my thinking. There are these which are meant for purely war purposes. I think Lieutenant General Herrero here will help me. He's the one who knows those things. This one you use to to do very bad things to other people. No, that was your one. You know, those you use to attack enemies. For example, you know, like an artillery piece. There is this one with too many guns, too many bullets, or whatever it is. Yeah. Or either Honorable Chama Sweat or the other one who said it was a... Okay, let me conclude. I don't want to excite people. There are those weapons, and Honorable Minister, you would get my support for those category of weapons, which we think are purely for UPDF. And no civilian should, under any circumstances, own, even whether lawfully or even illegally, own that weapon. That one you'll have my support. But there are weapons which I think cannot be said to be a monopoly. You can't say monopoly, then you go ahead and you bring almost all weapons and you say they are what? They are monopoly. I think there is a problem there with the law, and we need to address that so that we are so clear. These people who are charged with the responsibility of keeping us safe, and they have been given equipment, we want to protect the equipment. That one they use to keep us safe. But the other equipment which you share, including with the civilians, some of these MPs carry them, by the way. Even other people on the street, they are carrying these small pistols, and so on, they do. So those cannot be your monopoly, and don't bring them as a monopoly. Then the other issue, Honorable Chair, I think just look at these classified materials. There are some which shouldn't be here, like this is shoes. Yeah, please, please. If we had to start looking at shoes, this one looks like an officer's shoe. Really, Honorable Boss, please, 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 stop this. Stop this. Because people are going to start looking. So, by the way, this shoe is gazetted. Come on, it's for officers. Please, don't vulgarize the law, please. Because we are missing out on the serious aspect, and now we have gone to small little things. And you have taken us there. Please, please, I think review that, come back, and then we can move on the same page. I thank you, Mr. Chair.
I think we need to just go back and review what we are thinking about. But I think the law is talking about similar. That if I looked at it from a distance, what would I think that person is? If, for example, a person is running out of this building, putting on this uniform, wouldn't you ordinarily think that is for the soldier? That is where it is supposed to avoid confusion. So if you have a red beret like you have for NUP, if you're in a crowd, a person looking at you at a distance, would they think it is NUP or military police? That's the issue. So when the law is looking at those issues, it is looking at about the similarity and likely to confuse. Obviously, there will be extensions where we are discussing black shoes. So that is the comment on that. But I think that is a policy issue we need to look at and understand how can we best, what is it that we would look at as contradicting what the army uniform would be. And Honorable, the question of framing is criminal in itself. So, but that is another matter. If they are framing someone and putting a material in their house, that's criminal in itself. So we try to write a law, but we write the law for human beings. Human beings, by their nature, we try as much as possible, but they are going to fail in certain instances. That's why you have the laws. So it is that framing is definitely criminal, and we need to address it. And I think it's for us to think about what kind of safeguards can be put in place on both sides as Parliament. What safeguards can we put in place to ensure we address that issue? On the issue of Ogwang that Honorable Abdallah raised, yes, in that case, the court faulted the use of appeal as made by an instrument signed by the minister. The court said in the Ogwang decision that a minister cannot vest jurisdiction of appeal by an instrument. Jurisdiction of a court is vested by Parliament through principal legislation. So by bringing this here, we are asking Parliament to grant the principal jurisdiction not by statutory instrument, by principal legislation. So yes, it would be curing that. On the security of tenure, we discussed it and we can continue discussing it. The Army has a challenge on the stages of retirement, which are not necessarily the same as ours in the civilian life. In civilian life, we say a judge will retire at 65, and that person leaves the public service. But in the Army, people live at different stages of life. So some people live at 45, others at 50, others at 55, others at 60. So if you say that the person shall retire from the service of the court martial at, say, the age of 60, that person may be way past the stage of their retirement, but that's a consideration we could have. On your recommendation to have the DPP participate in prosecution, that would contravene Article 1, Honorable Abdallah. You had proposed that we have the DPP sanction the charges under the court martial, and I was saying that would require a constitutional amendment, because the Constitution under Article 123B specifically prohibits the participation of the DPP in matters before the court martial. Honorable Abdul Katuntu raised a number of issues. I'm going to leave the issue of the monopoly of the Army and etc. to the experts in these weapons. But what I know is that for the AK-47 to be used by police, it needs to get permission from the Army. That I know from my interaction with them. For prisons, even private firms to use AK-47s must get the permission of the Army. So, but they are here, they will be able to explain to you how that works. Then on competing jurisdiction, I see what you're saying. I think the only difference here is that if I have a firearm lawfully and I shoot someone using that firearm, and I shoot someone and injure someone, there is no question of me going to the court martial. It doesn't exist, because I have the firearm lawfully, but I've committed an illegality with that firearm. Yeah. Yes. Now that unlawful possession of the firearm will be charged by the court martial. But if you murder, if you look at the law, if you have an unlawful firearm as an individual and you go and commit murder without the assistance of a serving officer, you have the firearm illegally, you go and commit murder using it, that you will be charged in the court martial for that unlawful possession of that firearm. So if you have it lawfully and you use it for an unlawful act, you will be tried by the civilian courts. Why? Because at least you made the effort to go and report yourself that I have a gun. So that is the thing. Now, on parallel jurisdiction, I think the issue would be you can be tried in both places, and that happens in many instances. You can be tried in both places, but I think the issue is that both of them have jurisdiction. Both the High Court has jurisdiction over the murder you have committed, and the court martial has. The issue that we have is that if you are in concert with a soldier, then the court martial also has jurisdiction. Now the problem we are having is that if you take the soldier the other side to be tried in the court martial, and you take the civilian this side, the trial of those. Yeah. In two different places, yes. So the issue of possession of the firearm and the detail of it is what I'll leave to the experts. Because some experts sent me here, that, like for example, there is a bayonet which is attached to the gun. That bayonet which is attached to the gun, they're not expecting you to find it in a shop roaming around with it. That bayonet is the preserve of the Army. So, but they'll give you more detail. To the Court of Appeal, we're just borrowing an experience from the industrial court. We're just borrowing an experience from the industrial court, where the industrial court decisions are appealable to the court of appeal. But that, again, like I said, the jurisdiction of any court is determined by Parliament. Clause 57, I wanted us to, Honorable Katuntu, to raise clause 57, and maybe it may be our drafting which we may need to clarify. Clause 57, any party to the proceedings of a court-martial who is dissatisfied with the decision of the court-martial shall have the right to appeal to an appellate court on any of the following matters: legality or propriety, legality or the whole or part of the sentence, severity or leniency. Subsection 1 shall not affect the operation of any sentence imposed by the court-martial other than the sentence. So here, what we're trying to say here is that if a person is convicted of and sentenced to death, you cannot go to the court of appeal and say, what is the legality here? What is the severity here? The person sentenced to death should be at liberty to bring whatever issues that they may want to bring. Secondly, you cannot execute that death sentence before this person has exercised all their appeals. And if the person is appealing to the court of appeal, you must wait for the court of appeal. But if a person has been sentenced to 20 years in prison, he starts serving the sentence. So I think it's an issue of drafting.
No, that's bad. This is bad drafting.
Yeah,
I hear you loud.
Yeah.
But this is not what
it
has to be redrafted.
When you're speaking to it, I could understand where you're coming from. I think we'll need to clarify on the drafting there. And then on you at page 15 and on the composition of the court-martial, I think what the military was looking for was co-opted. This person is co-opted. What this provision is saying is that the president has the power to co-opt someone into the high command. So that is what EU is saying. And 7E, people should be a member of the high command. That is a policy issue, like you said, and they will help us with. What is the issue? I agree with you. The issue of civilians in court-martial. I'm going to end with the most controversial, because it was a question that channeled through almost every question. And I want to go there last, so that I can leave immediately after that. But but it is a matter that I need us to be clear about. I think, Honorable Nyeko, what my statement says is exactly what the bill is saying in 31D. What you're raising is in 31D, the clause 31D about what can be murder. This one here does not give the court-martial. 31D does not give the court-martial the jurisdiction to try murder. It doesn't give them the jurisdiction to try murder per se. It can only try murder if it is aided and abetted by a soldier. So if I'm a civilian and I go and commit murder on my own without anything, without the assistance of a soldier, the court-martial has no jurisdiction over me. Yeah? But if I committed it, if we went and broke into, you see the issue, and colleagues have spent some time with these men in uniform, and they've taught me a few things. The issue here is there are skills that they acquire in their training which are not available to you, a civilian. When a soldier is jumping over a wall, he has a skill which has been given to him in the military to use to defend the country. Now, if you, a civilian, were to get over a wall, you may need a ladder, ropes, and a soldier may not need that help. So when this soldier comes and jumps over the wall, then opens for a civilian, then you go in and commit murder. You have used a skill available to a soldier in the commission of your offense. So what the military is telling you, you want to commit your offenses, go and do it alone. If you do it alone, the court martial will have nothing to do with you. But if you go and involve a soldier in it, you're bringing yourself into the ambit. That's what that provision was saying. And Honorable Mpuga, you are talking about what provisions give, and I hope I understood your question to mean what in this law makes the court martial a court. If I understood it correctly, then I refer you to clause 35.9, clause 36.13, and clause 38.9. The creation of a court is by vesting it with jurisdiction. The moment the parliament vests a tribunal or a court with jurisdiction, it has become a court. So that's what deals with that. On the issue of the vice, I think that they've had Honorable Chair,
can you clarify? And you see, that's where the Honorable went on to ask, why then appellant jurisdiction is from the court martial to the court of appeal? Is it then a high court?
No, a stage where we believe that this jurisdiction is dropped in a particular way. For example, for appeals to an election petition, this parliament said you will not appeal to the Supreme Court. So what this parliament vests you with is what you use. The industrial court was vested with mandate and sent to the court of appeal. It was by this parliament. So the constitution did not tell this parliament where to vest the jurisdiction. So you can vest the jurisdiction. The
No,
question
but you
is,
see at that point, as you realize, the court, the industrial court was now being presided over by high court judge.
and now we are, you see, the industrial.
That's why we said no, we cannot have a high court judge in the industrial court taking a decision that is being looked at by a judge of the similar rank. Therefore, it should go up.
I think that is a conversation you'll have, but you must remember that the industrial court also has 2 civilians who are not necessarily legally trained.
AG.
So, but that's a conversation that what I need to state as a matter of law, the decision on the jurisdiction to be granted to any tribunal or court vests with the parliament. So we are asking you, parliament, to grant the court of appeal jurisdiction over the decisions of the general court martial.
AG, this is just for your take home. I beg to disagree with the use of the example of the industrial court. We are talking about a criminal offense here. It's homework for you, but I want you to address that.
I think it's homework for the parliament, because me, I am not the one who vests jurisdiction.
Yeah.
Me, I've asked you, and I've told you what we think, and the reasons why we think so. Now,
Mr. Chair,
Okay.
we are not trying to pull ropes here.